Hi, guys, and welcome to another episode of Keeping It Legal, where we break down complex legal issues to simple, plain language. I'm one of your hosts, Shante Wilson.
And I am Hugh Hudson, Attorney Hudson, and we are coming to you from the Hudson Law Group.
Yes, and today we'll be diving into another interesting, very insightful topic.
Also very relevant.
Very relevant, yes, very relevant. Removal proceedings.
That is true. Today we're going to talk about removal proceedings. I know you all have been watching the news and learning about immigration, whether you like it or not, because it's all over the news these days.
Yes.
So we're going to talk about the process, how it's done, where it is done, and we're going to go over some defenses as well from deportation proceedings.
Yes. Well, like our past videos, we like to start with a workable definition, right?
And as you all may notice, Shante said removal proceedings. I said deportation proceedings. It is the same thing. Yeah. Some people use deportation, other use removal. Sometimes I use either or. Doesn't matter. It's the same thing.
Okay, great. So start with a workable definition. What is removal proceedings or deportation? So removal proceedings is a legal process in which the U.S. government seeks to remove an individual that is not legally here or is not a citizen of the United States.
That is true. So non-citizen, I think anything short of a U.S. citizen anyone short of a U.S. citizen could face deportation proceedings at some point. And we'll talk about it. But yes, you're right.
All right. So how do we start the removal process or removal proceedings?
So the removal or proceedings begin when you receive a notice to appear, an NTA. Right. So what the notice to appear is the government displaying or detailing the reasons why you should not be in the U.S. It's like your charges in the sense of criminal laws. If you were arrested or you were charged with a crime, you will get an arrest record. Your arrest record will state the allegations to which you are being arrested for.
Right.
Here, your notice to appear in immigration court would state the reasoning behind why the United States government thinks that you should not be here.
Right. What are some of the grounds you can get a notice to appear on?
So there's several ways, several means in which one could be issued a notice to appear. Right. If you're here and you have accumulated any unlawful presence, i.e., if you initially came and you came to the U.S. on a visa and you've overstayed a visa, from the time you've overstayed, you are now accumulating unlawful presence, right? Okay. And then if you have accumulated any unlawful presence, then you are subjected to be put in removal proceedings. So we have, a lot of individuals come to the U.S. on the visitor visa.
Right.
Typically, the visitor visas are 6 months. They're valid. They're valid for 6 months.
Right.
Anytime over that 6 months, then you are subjected, or you could be put in immigration proceedings. You can also be put in immigration proceedings if you are applying for admission to the U.S. Some people will enter the U.S. Let's say you have a visa, right, but on this time you're entering the U.S., CBP determined that you may have worked the last time you were here, or you may have overstayed the last time you were here. They decide to not allow you into the U.S., right? So they, instead of allowing you to the U.S., they will put you in detention, and they will issue a notice to appear in front of a judge. And at that point, you will be an arriving alien, so someone that's applying for admission into the United States.
Right.
Also, in the sense of lawful permanent residence, if you have committed a crime, depends on the severity of that crime, you could be placed in deportation proceedings. So even if you have a green card and you were then you committed a aggravated felony,
right?
It's an aggravated felony, is a dangerous felony. So attempted murder, assault, battery, and those kind of really severe crimes, then you could be put in proceedings, and you will have to defend your proceedings even though you were a lawful permanent resident.
Right. Let's say, the NTA has been issued and now you are detained. Do you want to explain what detention is for our viewers?
Yeah. So you could be issued an NTA without being detained, right? Also, you could, depends on the reasoning behind the NTA being issued, you could be placed in detention.
Right.
The example I just give with a lawful permanent resident or anyone really that commits a aggregated felony, it is likely that you will go to jail, not federal, but state or federal prison. Once you are in prison, ICE will have a hold on your release.
Okay.
So ICE will communicate with the government and let the government know this individual should not be released until we are there to then detain that individual. Right. Okay. So when you release from state or federal prison, ICE will then apprehend you and detain you into immigration detention, and they will put your case in an expedited processing, meaning that you will have a faster hearing. This is not to your advantage, but you will have a faster hearing because you will be detained in the immigration proceedings.
Right, and while being detained, you do have a right to bond. You do have a right to have someone bond you out of detention.
Yes. Yeah. So detention, in terms of the people who show up at the border, this happens a lot. So anyone that shows up at the border, they are automatically put in deportation proceedings.
Right, because of their status.
Because of their status.
Here, right? Or no status, because they're here illegally.
Yes, the lack of status. So they came and they may have applied for status, or they may have let the CBP, the agents at the border, they may have let them know that they are fearful of returning. But because of the manner in which they came, they're automatically granted or given, rather, a notice to appear. Some of them are detained, right? But once you are detained, then you can seek bond, right? So bond in immigration works the way bond does with any other area of the law, where you have to show that you're not a flight risk, you are not a danger to national security or a danger to U.S. citizens,
and also that you will comply to the conditions at the court.
That is true, right? So if they deem that you're not going to comply, you're not going to show up to court, they will not grant you a bond. So when you have your bond hearing, you will then given an amount. The judge will then grant you bond based on or contingent upon someone paying a certain amount of money. And once that money is paid, you are then will be released. I do want to mention there are certain NTA that does not give rise to bond, right? There's certain detainees that are detained and they are under mandatory detention. Right, so if you commit a certain crime, the aggravated felony, which I mentioned, because that automatically give rise to you potentially being a danger to a U.S. citizen, then you are subjected to a mandatory bond. Right.
So bond.
Monetary detention. You're not eligible for bond.
Okay. So the bond. So whether you get bond or not is determining on whether you were convicted of a crime or how you were detained.
Yes. Okay. Yes, and also that the judge deemed that you will participate with the proceedings, so that you're not a flight risk. Also, arriving aliens, people who are applying for admissions into the United States, they are also subjected to mandatory bond. I don't know why I keep saying mandatory bond, mandatory detention. They're not eligible for bond. Just to correct the record.
Okay. Yeah. So after the NTAs is issued and you get the notice to appear, where are you appearing? You're actually appearing to the immigration court. And with this immigration proceedings, you have two hearings. So you have the master calendar hearing and also the merits individual hearing. From my research, I understand the master calendar hearing is a very short, very brief hearing in which the detainee is allowed to plea, whether guilty or not guilty.
Yeah, that is true. So the immigration courts have been created under the umbrella of DHS. The DHS is the Homeland Department of Homeland Security,
right?
Which is under the purview of the executive branch, the president. Right? The president, by way of the Constitution, is tasked with protecting the U.S. from foreign or domestic terrorists. So essentially, the president has powers over the immigration proceedings, right? And the Department of Homeland Security has created the immigration courts, right? The immigration judges serve as that impartial individual that will listen to someone's case,
almost like a mediator.
Like a mediator, yeah. So someone is supposed to be impartial that will assess and judge the laws on the book, judge the cases based on the laws or precedents and also the policy of the department, and make a determination whether the U.S. could remove this individual or the U.S. could not.
Right. So after your master calendar hearing, then you have the merits hearing.
Mm-hmm.
And this is where you have to actually put forward your case in front of the immigration judge.
Yes. Mm-hmm. Yeah. So you were saying that the master hearing is an opportunity to go through pleadings, to determine the charges, to either accept those charges or you can choose to deny those charges. If you are denying the charges, you have to state your basis for them.
Yes.
And you have to kind of make a case in front of the judge. I would say that a lot of cases, a lot of my cases are dismissed at that initial master hearing, because this is where you'll kind of go through the charges, and sometimes the judge will disagree with the basis of you being in deportation. In essence, the judge agrees with me, the attorney, the defense attorney, and the judge will agree to dismiss the case and deem that no for the hearing is necessary, right? Because again, you have DHS making this case, and then you have your lawyer, the immigrants or non-citizens lawyer, which would be someone like myself. And then based on my argument, the judge may determine, all right, well, there's no need to proceed because, for instance, the charges that placed you in immigration proceedings have been dismissed. Mm-hmm. So therefore, there's no basis for the judge to move forward. Right. There's also certain waivers and things like that you can argue in front of the judge. You can also assert that you're not removable. Right. So if you had certain statuses like TPS is temporary protected status. Mm-hmm. If you have temporary protected status, you have a stay of removal. You cannot be removed to your home country because you have protection from removal. And if you have that, you show up to a master hearing and your attorney argue the fact that you are not removable, then the judge will dismiss the case.
Right. And as we stated in one of our earlier videos, I would think it was the asylum videos, immigration is very nuanced. So in order to get a successful case, you have to have an attorney.
Yeah, I'll agree with that. Your chances of winning your case or winning a case or defending yourself from deportation proceedings is slim to none if you don't hire counsel. It is, it's well known that attorneys are expensive.
Yes.
Right, but
it's your life.
We serve a purpose, right? It's your life, it's your livelihood, your future, right? And the immigration system is very, very brutal. It changes a lot. It's hard for attorneys, the people that are working in this field, like myself, to keep up with the changes that's happening, let alone someone who's not versed in this area.
True. And unlike criminal proceedings, a lawyer is not afforded to the individual. You have to go and hire counsel.
Yeah, so there are a lot of nonprofit organizations, but those organizations tend to be full. They tend to not have space, and if they do have space, they will not be able to take your case immediately. But you are not entitled to a lawyer by the Constitution, like you are defense counsel in a state matter or something to that effect.
Okay, so we're wrapping up now. What are some of the forms of relief you can get from removal proceedings?
Great. Yeah, great question. So there are many ways you can defend your deportation proceedings. Again, deportation is the United States government saying that you don't belong here, and therefore we will deport you back to where you are from. Right? When you are placed in deportation proceedings, other than the argument about your criminal conviction being dismissed or asking for dismissal, if that doesn't happen, the judge will then grant you a date to which you have to file your defensive application, right? So you have to show the court, this is how I intend to defend my proceedings.
Right.
The judge will say, all right, we'll have a hearing on December 5th, 2025. Your application is required to be filed at least 60 days prior to the hearing, right? You then need to assess, or your lawyer will assess with you, the best course of action to defend yourself from proceedings. Some of which we've discussed before, the asylum, withholding and removal, and CAT, which are all on the same form, right?
Right.
What is that? Do you remember the name of that form? Just to put you on the spot.
The application for asylum and withholding. Oh yes.
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 Form I-589. Right. So
yes.
that is the application that you apply for when you fill out and submit to the court with evidence. So it's more than just filling it out.
Right.
And you will always check the boxes for withholding removal and CAT.
And some of the reliefs that you haven't mentioned are adjustment of status or canceling removal.
So you have more than just the I-589. You can also file or apply for adjustment of status, which requires you to be married to a U.S. citizen or have U.S. citizen children that are over 21.
Or canceling removal.
Or you can cancel your
So we haven't spoken about AOS or canceling removal. You want to speak more about canceling removal in this video?
I could speak briefly, but I think we're going to get into maybe its own episode dedicated to adjustment of status and also cancellation removal. But in essence, cancellation removal states that if you've been in the U.S. for more than 10 years and you have demonstrated that you have good moral character, and you have and this is the hard part, you have a qualifying relative that will suffer extreme hardship should you be returned to the U.S. to your home country.
Right.
That qualifying relative has to be a U.S. citizen spouse, parent, or a child. Right. And the word extreme is in there for a reason. It's a little bit difficult bar to reach, but based on your situation, your attorney will assess with you whether you are qualified for cancellation removal. Also, the adjustment of status, if you're married to a U.S. citizen, like I stated, or you have a child that's over 21, or if you're a child younger than 21 and you have a U.S. citizen parent, you can apply to adjust your status depending on how you enter the country. I'll say that as well. You have to have entered the country legally,
right?
Notwithstanding the fact that you may have overstayed, but you have to have had that lawful entry,
port of entry. Right. Well, guys, we're wrapping up this week's episode of Keeping It Legal. If you or anyone you know need any legal advice, feel free to reach out to the Hudson Law Group. We are ready to serve. Of course, yes. And we will discuss further details, adjustment of status, also not withholding removal. We've already done that, but cancellation removal. In future episodes, we will also have an opportunity to bring some guests on and talk more about some of our successes. Yes. And we'll actually have our the rest of the staff from the Hudson Law Group join us at some point. Yes. So we can introduce everyone to you all. In the meantime, keep liking, sharing the videos, and we will see you soon. Bye, guys.